Well, good morning, everyone. We are here on State of Indiana versus Richard Allen, 08C01-2210 MR1. I'll show the defendants here in person with counsel, Mr. Rozzi and Mr. Baldwin. The state is here by the elected prosecutor, Mr. McClelland. We are here. Originally, we set this hearing on the defense motion for a change of venue. I would just remind everyone that the court has again issued a management and decorum order for this hearing. At the conclusion of the public portion of the hearing, ladies and gentlemen, I will clear the courtroom. There is an ex parte matter that we need to attend to with myself and counsel for the defense. The defendant will remain. The prosecutor and all of you will be asked to leave the courtroom. I think my security detail, which is Officers Bode and Tinkle, will remain in the courtroom. I believe the gentlemen that have escorted Mr. Allen into the courtroom will also remain in the courtroom. At the conclusion of this hearing then, we will take up the ex parte motion. Since the scheduling of the hearing on the motion for change of venue, I have added, on my motion, the state's motion to prohibit parties from disseminating information that was filed by Mr. McClelland on November 22 of last year. Additionally then, I set the supplemental motion for discovery that was filed by the defendant on December 30 of last year and the state's response to that motion, which was filed on January 12 so we need to take care of those things. I appreciate, those of you in the audience, I appreciate your patience. I know the hearing was scheduled for 10 o'clock. I met with counsel in chambers to discuss procedural issues and to kind of figure out where we're at with everything. So I did grant the state's motion. I know we keep calling it a gag order, it's the motion to prohibit folks from discussing things. I did grant that motion pending this hearing. We've had the opportunity to discuss in chambers the professional responsibility of counsel, the requirements that they are permitted, under the rules of professional responsibility, to discuss procedural matters, potentially to discuss the upcoming bail hearing that's currently scheduled for February 17 and that is basically the extent of what the attorneys are permitted to discuss with members of the media or the public. I would remind those of you that are in the courtroom that are family members and potential witnesses in this matter, you are also covered by the gag order, and I would ask that you respect the gag order and not discuss with the media the facts of the case, your testimony. Anything that would be inappropriate for the attorneys to discuss would also be inappropriate for you to discuss, and I appreciate your continued honoring of that order. Is there anything else on the gag order that we need to discuss on the record, Mr. McClelland?
No, Your Honor.
Gentlemen for the defense?
No, ma'am.
So my recitation of our discussion adequately has been reflected in this record?
Yes, Your Honor.
Thank you.
Yes.
I know the discovery in this case is more than voluminous, it's extraordinarily voluminous, and I know that the state has an open file policy basically, where you give everything to the defense. I appreciate that, I'm sure the defense appreciates that, but I know, as well, there are just thousands of pages of discovery. What I would like to do, gentlemen, is I know that you've been working very diligently with each other to discover information back and forth. Mr. McClelland, you've provided, so far, everything that you have, and I appreciate that you've been categorizing that information for the defense. I know that the defense has the opportunity then to recategorize it as you see fit for your purposes. So rather than rule or do anything on the supplemental motion for discovery that was filed by the defense and the state's response thereto, I would like to take that under advisement to give counsel the opportunity to work as diligently as you have been working. I have shared with you some of my thoughts about the discovery and, again, I appreciate that the state has been very diligent in providing information to the defendant, and I trust when the defendant acquires information, it will be as diligent in providing that to the state. Is that an accurate statement, Mr. Rozzi and?
Yes, ma'am.
Mr. Baldwin?
Yes.
So is there anything further we need to discuss about discovery, or does that reflect what we discussed in chambers?
In the state's perspective, that reflects what we discussed in chambers, Judge. Thank you.
Mr. Rozzi, Mr. Baldwin?
Agreed. Yes.
Okay. Very good. All right. Then we have the motion for change of venue that was filed by the defense. Thank you for the good advocacy on behalf of Mr. Allen, Mr. Rossi, and Mr. Baldwin. I think it's patently clear from the filing that you provided to the court that it would be difficult, if not impossible, to find a jury here in Carroll County, Indiana, that would be not involved in some fashion with the underlying investigation or the facts of the case. Mr. McClelland, it's my understanding that you agree with that it would be difficult, if not impossible, to find a jury here in Carroll County?
Correct, Your Honor. I believe that's accurate.
Okay. The statute, however, gives the court the opportunity, rather than completely venue it to a completely different county, that the statute does give the court the opportunity to recognize that we cannot, in fact, select a jury in Carroll County from Carroll County citizens, but that we could go to another county and select a jury and bring them back to Carroll County, so that the trial could be conducted here in Carroll County. Is that fair?
Judge, that is fair, yes. I believe that's the case.
Okay. Mr.
Agreed.
Rossi? Okay. I think it's really important that we try this case here in Carroll County. I think all of the witnesses are here, the families of both the victims, as well as Mr. Allen, friends are all here. I think the expense to witnesses for both the defense and the state would be extraordinary if we were to take this case outside of this county. So my preference would be to acknowledge that we cannot get a fair jury here in Carroll County, but rather, go to another county and select a jury from another county and bring them to Carroll County. I have my financial coordinator here with me, as well as my court executive and director of court operations. They've been looking at other potential areas that we could select a jury from. I know we had some brief discussions in chambers about some particular counties that we might go to. I know that you've had the opportunity, Mr. Rossi and Mr. Baldwin, to speak with Mr. Allen about that. And what I would like to do is to ask counsel to notify the court within a week from today's date if you have agreed upon a county that we can go to select a jury. So I would accept an email from you gentlemen that you have agreed upon a county, and then I can contact whatever county you have agreed upon to see if they are able to accommodate us. Is that acceptable to the defense?
Yes, ma'am.
Mr. McClelland?
Judge, yes. And again, it's important for the state's perspective to try the case here, and I'll work diligently with defense to attempt to find a different county to pick the venire from, Judge.
Okay. All right. I think, other than the X part, is there anything else that we need to discuss on the record, Mr. McClelland?
Judge, I just want to confirm the February 13th date is for the let bail hearing and from the state's perspective, I don't know of any other motion to date that we need to discuss on that day, and I want to confirm that with the court.
Actually, it's February 17th.
The 17th. I'm sorry. Today's the 13th. February 17th, yes, Judge, at
Friday the 17th, and that
10 o'clock. Is that correct?
Yes.
Okay.
10 o'clock and that will be here. That's also our omnibus date.
Right. Okay.
I know that we have a trial scheduled in March that was scheduled at the initial hearing back in October. I can't see that happening. I mean, you're both looking at me like, there's no way. Not gonna happen in October, sick.
I think we can. Can we just have an agreement that, and understanding that we'll address that at the bail hearing?
At the bail hearing?
Yeah. I think we're all on the same page about.
I'm satisfied with that, Judge.
Realistic.
I don't anticipate it happening in March. I think that's ambitious, but we can address at the omnibus hearing, Judge, that's fine.
Ambitious, that's a good way to put it. Okay. So nothing then else from the state?
No, Your Honor.
Mr. Rossi?
No, ma'am.
Okay. Then, the bond hearing, the Omni, and A.
No, Your Honor.
No.
No? All right. Thank you very much. We will, then, proceed into the ex part, and I know that the gentleman ringing the courtroom from the law enforcement will escort all of you out of the courtroom, including the state of Indiana.
Thanks, Judge.
Thank you. This concludes the proceedings had at the hearing held January 13, 2023, in this cause.